Good morning, everyone. And today we have got Tony Burke from Burke and Associates in our SBA Tales from the Trenches, Ep.2. Tony, good morning, and tell us a bit about yourself.
Well, thank you, Partha. Thank you for the opportunity. Well, I suppose, as you can see, I'm no spring chicken. I'm 66 years of age, and I've been a lawyer for a long time. But before I became a lawyer, I had a number of other jobs. I worked as a factory hand, I worked as a crane driver, and for a number of years I worked as a payroll officer at the Naval Dockyard in Williamstown. So I saw a fair bit of the world before I got back into law, and I gradually worked my way through a range of disciplines in the law. I must say I got fairly bored fairly quickly with a lot of things. I started off as a personal injury lawyer, but that became a bit boring. Became a family lawyer, moved on from that, became a commercial lawyer, did various other things. And then in my mid-50s, I started to become involved in legal politics. I stood for election and was elected to the Council of the Law Institute of Victoria. And within a couple of years, I found myself on the executive, and in 2008, I found myself as president of the Law Institute of Victoria, where I was the notional leader of some 18,000 solicitors in Victoria. And as an adjunct of that role, I became a director of the Law Council of Australia at the national level for a couple of years. In the midst of all of that, Cathy Farrell, who has since become a federal court judge, put the weights on me to set up what's now the SME Committee of the Law Council, which represents small business at the federal level. So my career went, and when not being a lawyer, I've been fairly heavily involved in community activities and particularly sport. Been involved in a lot of cycling, a lot of triathlon, open water swimming, and so on. I've been to a couple of international events representing Australia in triathlon, and several years ago I had a failed attempt at swimming the English Channel. So that's me in a snapshot.
Wow, so that's fantastic in terms of you have such varied life experience beyond law, and it's really interesting to sort of get an overview of that. So what got you started on succession planning, Tony?
Well, Partha, I think it was pretty much a convergence of events coming together that caused me to realise how important it all was. As my career developed, I became more and more involved in commercial law and commercial disputes, and it became obvious after a while that the bane of existence for people in small and medium businesses was the lack of preparation about succession. There were endless partnership disputes, shareholder disputes, this sort of thing. And almost invariably there was a lack of a foundation document that addressed the internal governance of the organisation and that sort of thing. So that was one of the factors, the cumulative effect of the work that I was doing. Then in the course of my year as the Law Institute president, I went to a number of overseas events. One of the ones that I went to was an International Bar Association conference in Buenos Aires, and I remember very clearly going to a session at that conference conducted by a rather prominent lawyer from Adelaide in South Australia, and he was talking about some technology in his own firm, and he was speaking about his experience, or his firm's experience, dealing with large-scale workers' compensation claims on behalf of insurers. And what they'd done was apply a bit of data analytics to the material that they had, and they were able to discern some trends and some patterns of behaviour, which then made it possible for their insurer clients to mitigate risk, control the incidence of claims, and thus save money.
Yep.
And it was a fascinating discussion, which was all about the convergence of database management with law. But amazingly, out of the 200 or so people who started off watching this presentation at the conference, only about 25% were there when he finished. People just got up and left because they couldn't see the relevance of it. And for me, it just drove home really clearly that law was changing, technology was converging, and we needed to get ourselves ready and organised if we were to survive in the future in law. So that's the second one. So the first driver was my involvement as a business lawyer, then this moment in Buenos Aires. Then there was my time doing the rounds with the Law Institute. As it turned out, in the 150 years or so of the history of the Law Institute, I was only the fifth lawyer who was a sole practitioner to take on the role as president. And invariably when I went to speak at country law associations, suburban law associations and so on, that would come out.
Yeah.
And I would find that lawyers would come up to me in the margins or in the corridors and on the quiet and ask me about succession planning. These were people about my age, and it became very clear they had no idea. They had no plans, and there were no ready experts to go to. And this became concerning. So I started agitating through the Law Institute that there was an unmet demand and the need for some work to be done. And to its credit, the Law Institute invested some resources and developed some programs and rolled out a series of presentations. Sadly, they didn't see the light of day until about 2 years after I was ringing the bell, but that's how long these things take. So that's number 3 in the drivers. The fourth one was the training I did with the Australian Institute of Company Directors, and I've got to admit that before my year with the LIV as president, I was absolutely terrified. I was fearful that I was going to muck it up and my practice was going to suffer. So I invested my own money in doing a number of courses, including the AICD course, which costs about $8,000 minimum. And that was all about succession planning as well, and how to create a shareholders agreement and so on. So effectively there were 4 key points that came together and heightened my appreciation of how important succession planning was.
Talking about succession planning, Tony, if you can tell us a bit about your own experience in your practice with personal succession.
Certainly, it's all very well to talk in the abstract. It's where the rubber meets the road that it really matters. I had the experience at the Law Institute that I've told you about. I'd also got to that point in my practice where I was getting a bit frustrated. I've always been someone who likes to refresh myself, do new things. But there comes a point in practice where the very size of your practice limits your capacity to do things. And I was beginning to find that as a sole practitioner with 4 or 5 support staff, I was being discounted by potential clients because they thought that I didn't have the ability or the capacity or the resources to be able to deliver And invariably what would happen is in some sort of conversation with a client about matter A, you would discover that there's matter B that the client's dealing with another firm of lawyers, and you knew nothing about it. And you might have had the capacity to do it, but you weren't given the opportunity. So to create the possibility for myself and the firm, I could see that I needed to grow, and growth implied some sort of succession. So that was one of the drivers. So after my year as Law Institute president, I focused on rebuilding my practice. It took a bit of a hit during the presidency year, but I focused on building a practice, and I recruited 3-4 lawyers in the course of a year or so and worked extremely hard on building things up. And I also set my goals on developing my own succession plan. I had the rocket of my experience with the LIV to draw upon. In previous years, I'd had a number of encounters with lawyers who talked about mergers and the like, and I'd had a number of encounters with HR consultants, but I'd found that really unsatisfactory. Dealing with the HR consultants and with a merger prospect, the conversations would go in a fairly predictable way. There would be an exchange of coffee and very general discussions about gross fees, then leading to a rather sheepish exchange of financials, then arguments about whose premises were to win, and invariably you got to a point where one of them, usually not me, would say, well, if I'm going to come into your practice and if I'm going to bring in these fees, I want you to guarantee my income and my security for a defined period of time. At which point I'd just say, it's either a merger or it's not. I'm not taking on an employee, and that would be the end of that. That had been an unsatisfactory experience that I had maybe 4 or 5 times over the previous years, and I was determined not to repeat it. So I resolved that I would create my own succession internally, which was not easy. I mean, I had recruited a number of lawyers, but they were all much younger than me, considerably younger, and certainly less experienced than me. So there are a number of cultural challenges, I suppose, that emerge, age-wise, experience-wise, and so on. And to give you an example of that, I ultimately persuaded 3 lawyers to become equity participants, and their background was completely different to mine. One of them was someone who was in her early 30s who had started work here as a receptionist and done law as a mature age 21-year-old. Another one had come to us as a temporary secretary. She was a law graduate from Queensland who was struggling to find a job. And the third one was someone who came from Tasmania, who swore and avowed that she would never consider equity with any law firm anywhere. So these were the people that I was trying to get across the line to become my co-owners. And so I had to do a lot of mentoring, a lot of training, and I outsourced a lot of that as well. I spent a significant amount of money on a number of undertakings in order to get them from the rank of rank amateurs, if you like, to the point where we could then have a meaningful conversation about equity. So, for example, I engaged my accountants to do some revised financials, so that instead of the usual set of financials that a sole proprietor might do, the financials were reconstructed on the basis that I was paid a salary at a market rate, showing the profit and excising all of the personal expenses that I might have been able to recover as a sole proprietor. So I was then able to present to them a set of clean financials which showed industry benchmark salary and a substantial profit. I also paid for each of them to go and do the FMRC course, which I mentioned earlier. So 3 lots of $8,000. Sorry, I said FMRC, I meant the AICD course. And I also paid for some management training for several of them with FMRC, which is a Financial Management Research Centre, which is a private management consultancy for the legal profession based in New South Wales. So eventually, a year or 2 down the track, we got to the point where the conversation became alive and we moved to a conclusion. Difficult process.
It's a very difficult process, and you invested significant resources in it, Tony, obviously, to sort of bring up the participants, as you put it, to a level where such a discussion was feasible and possible. So how did you say that you engaged FMRC and Sam Copeland to value the practice? So how did FMRC value the practice as a part of this process?
Well, I'm a big fan of FMRC, and Sam Copeland is a great guy. We provided our financials to FMRC, and my accountant liaised direct with them, and collectively they revised the accounts, and then we had some, if I remember correctly, we had an all-day strategic planning session here, chaired by Sam Copeland, where he walked through the financials. But essentially the process of revising the financials is quite straightforward. You take the firm financials, you excise all the abnormal stuff, you impute industry benchmark salaries for each key person, and you then calculate the profit. Hopefully there's some profit coming out the bottom, and to determine the value of the goodwill, we applied a multiplier of 2.28. So that then produced a figure. In my case, it was just on $1 million, and that then set the start for the conversation that led to ultimate equity transfers.
Interesting process, and obviously having FMRC's expertise to oversee that process helped you objectively get to a stage where...
Yes, but it's a very common methodology for the valuation of a business.
Absolutely.
Future maintainable profits, that sort of thing.
Definitely. And how did you structure the sell down as a part of post this valuation and the processes around it?
Well, of course, I wanted an outcome. I wanted this thing to get across the line. So I was a willing vendor, but a not, well, perhaps somewhat anxious vendor. We had the price, or the value of the goodwill and the bits and pieces around the place, the plant and equipment. And then I discounted that somewhat because I loved them.
Yeah.
Because, and I was also very mindful that there was a power imbalance.
Uh-huh.
So we came with a valuation and then structured it on the basis that there was an initial sale to each of the three of them of 10% equity, with an option for each of them to acquire a further 10% in the following year. And in the first go round, the terms were, you take the shares, but you don't have to pay me for 12 months. And in the ensuing 12 months, any dividends to which you're entitled are treated as part payment of your purchase price, in the hope that the profitability would be such that they would pay for themselves.
Yeah.
So that proceeded well for the first year. There's not a lot of cash flowing. Second year, they all exercised the option to take up more shares, and then there was another director came in later on. So in no time flat, I'm down to 20%. But there were significant other benefits, right? In the process, the firm grew.
Yeah,
we took
absolutely.
on other employees. Our capacity to do better quality and more remunerative work grew. My responsibilities as the sole owner diminished.
Yeah.
We had a portfolio approach around the table where there was an appropriate division of labour between the four of us, and I also insisted that, and this maintained the case until very recently, that we had an independent chair who was my accountant, or our accountant, and the brief to him was that he was to be the protector of the less experienced, the educator of the less experienced, and to ritually beat me up every now and then. And that's something that he took to with relish. So almost every board meeting we had, he would find some basis to give me a touch-up and be seen to be the protector of the others. And then a couple of years ago, I became sufficiently confident that my colleagues had risen to responsibility and accountability, that I stepped back from being a director, because I was concerned that my continuing involvement could be a dampener on the conversation. You know, I'm heading to retirement and they've got a long life ahead of them in the law, so best not to hear from the old man.
Yeah, that's fascinating to me in terms of the process that it created to make it work over a period of time for the incoming partners and the opportunities that you created for them.
Yeah.
So how did you feel it went overall, the process?
Well, I don't know how it would have been otherwise, because I did not have that experience. But I'm told that our experience is exceedingly rare. I hear that from people like Sam Copeland. I hear it from other lawyers. You may have also told me. I can't remember.
Absolutely.
It's a fairly rare phenomenon, and so in the space of 10 years, we've gone from me as a sole practitioner with 4 or 5 employees, with probably minimal or zero saleable goodwill, to a firm that now comprises about 20 people, and which is still growing, and led by very capable people who have all in the leadership group been deeply immersed in high quality governance training and management training, and who have no excuses but to succeed. I'm very, very proud of that.
And that's very unique, Tony, in the sense that obviously for you, the succession planning has meant practice growth, whereas for many other firms or practitioners, probably the mindset is very much around exiting from the business in a quick time frame, where we have taken a much more long-term view where the firm has grown in that period, and it's fairly unique in that sense.
Yeah, I think perhaps the key takeout is that as a sole practitioner or a small firm practitioner, your exit opportunities are not good.
Mm-hmm.
They become significantly better, and the transition becomes somewhat easier if you take a chance and you embrace growth and good technology, and all sorts of other systems. I mean, for example, we've put a lot of money into technology and practice management, and our association with SBA has worked particularly well, and we're now far more efficient in what we do than would otherwise be the case.
And you are an innovator, Tony, in that also you're one of the earliest adopters of SBA and and the services that SBA provide.
Yeah.
And you played a big part in the change management also around getting your other partners at that stage to go across to SBA's offices in India to see how
that's right.
outsourcing can work for a practice like yours.
Yeah, that was a pivotal move. I remember initially having the discussion with my leadership colleagues, and there was considerable apprehension, and then we bit the bullet, and I said to two of our directors, jump on a plane, go to India, have a look for yourself, and train them in the way we do things and learn from them in the way they do things, and let's see how we go. So Christy and Jess jumped on the plane and went there and spent a week with your colleagues in India and came back, and we've never looked back. It's been fantastic.
Thank you, Tony, and thanks for the great insights on succession planning. We are confident that we'll probably get a lot of questions out of what we have discussed today.
Yeah.
So there will be an ebook available out of these discussions on the podcast today for practitioners to get more insights from on this process of succession planning. Thank you for your time today.
Thank you, Barbara. It's been a pleasure.